me welcome you all and to thank you for being here with us today in this exceptional event with distinguished speakers attending both in person and online. As we also have a guest from Greece, please know that interpretation is provided in English and in Greek. And I will now switch to Greek for my introductory remarks on the purpose of this event and the key issues that will be addressed. Η ενδοοικογενειακή βία είναι θέμα που μας αγγίζει βαθιά και μας εξοργίζει.
Domestic violence is an issue that touches us deeply and outrages us. Those of us on this panel have been fighting for many years to eradicate gender-based violence, which in all its form is an extreme form of discrimination and a flagrant violation of human rights. However, the progress made in the fight against violence against women is disproportionately small, and gender-based violence remains a global scourge currently exploding, which is often glossed over and its true extent is not reflected. 1 in 3 women has experienced the nightmare of gender-based violence, often within the family environment, without the necessary protection, justification and support. Incidents of abuse are on the increase, and the sad list of femicide is constantly growing. We mourn victims of crime that could have been prevented in time, and that is a failure on all our parts. Anger is not enough. Strong, comprehensive institutional framework and adequate mechanisms are now required to eliminate current legislative loopholes and distortions that do not fully deter abusers and perpetuate violence which is being reproduced and multiplied. Today's event is therefore of particular importance and significance, not only because of the excellent speakers who have accepted my invitation. It will help to highlight critical dimensions of domestic violence that have not been adequately assessed and addressed. But above all, because it takes place at a time when the European Parliament is preparing its position on the proposal for European Directive on gender-based violence presented by the Commission in March 2022, which is expected to be adapted in its final form later this year. As members of the European Parliament, we have the opportunity to shape developments by tabling amendments in the coming days on a number of individual issues that we believe can make a difference to victim protection and prevention. And at this point, I would particularly like to thank Andrea Trezzo, a former UNAMID official with experience in equality issues and very active to date in the fight for women's rights, who provide us with considerable help and support in organizing this event. The aim today is to highlight the real dimension of the impact of domestic violence and custody rights on women and children in European member states, and to propose solutions that will improve the Commission directive. In this debate, we're not starting from scratch. The European Parliament has taken a clear position on a series of resolutions and has made specific recommendations so that the European Directive, which will be formulated and adopted in its final form, will eliminate current legislative distortion and contribute substantially and effectively to the treatment and prevention of all forms of gender-based violence. I had the honour to be the rapporteur of the European Parliament and to draft the report that was adopted in its entirety by an overwhelming majority 1.5 years ago in the plenary of the European Parliament on the impact of intimate partner violence and custody rights of women and children. We have adopted a progressive report that has at its core a comprehensive framework for the effective protection of victims and the resolution of parental custody issues with the best interests of the child at its core. For the first time, we have put the focus not only on women and children, who must also be recognized as victims of this form of violence, and we sent a clear message: co-parenting is desirable, as it is a right and obligation of parents to actively participate in the upbringing of their child. However, co-custody cannot be made compulsory, especially when there is even evidence of domestic violence. We emphasize that the failure to recognize and address incidents of intimate partner violence in determining child custody and visitation right is a violation of women's and children's right to life and to life free of violence, and is inconsistent with the best interest of the child. Unfortunately, today, in several member states, the impact of domestic violence on women and children is underestimated when decisions are taken on the custody of a child. And although child abuse is a clear criterion for determining custody in case of a domestic violence against the other parent and not the child, it is often ignored. In some member states, domestic violence against women is often neglected, and the basic rule of joint custody prevails, with parent-centered rather than child-centered laws. There is a lack of temporary mechanism to suspend parental custody from a violent partner during legal proceedings, but they are usually delayed for several years. In this way, the abusive parent is given the opportunity to continue his or her abusive activity towards the former partner or the child undisturbed on the sole basis of his or her claim to care or communicate with the child. As a result, victims remain exposed to repeated violence, are effectively unprotected against violence, and in extreme cases, crime of femicide and infanticide are recorded. Moreover, it's particularly worrying that in several member states there is a bias in the definition and interpretation on the principle of the best interest of the child, which is unfortunately often defined as maintaining contact with both parents or their relatives at all costs and regardless of the violence experienced by the children. Equality cannot be measured by gender, and the right to a life free of violence and a life free of violence is everyone's business. We must continue to fight for zero tolerance of violence and in practice for strong mechanism to deter gender-based violence, for a change of mindset, striking gender-based violence at its root. The phenomena of sexism and violence in their most extreme form have no place in our modern society and must finally be eradicated. It's our duty to stand by every woman and a right to live a life free from violence, from fear, and even from the stigma that follows. Finally, it's our duty to create the self-evident framework which unfortunately does not exist today for the protection of the child and for every child's rights to healthy development and a life free of violence. Thank you. Before we start with statements of our distinguished speakers, I would like to ask to keep the scheduled time for the smooth flows of our today's event. At this point, I would like to welcome the President of the SEF Committee, Mr. Robert Biedroń, whom I thank for responding to my invitation to participate in this event. Mr. Robert Biedroń will talk to us about the role that the European Parliament, and in particular the Committee on Women's Rights and Gender Equality, the FEMM Committee, has played in the fight against gender and domestic violence. President, you have the floor, and then unfortunately we'll have to leave us. Thank you very much. You have the floor.
Thank you very much, Elena, and thank you very much, colleagues, for having me here today. And I'm honored I'll be speaking about this important topic together with other men, like our Vice President of this House, my friend President Papadimoulis, who is with us. Welcome, Nitros. Thank you, other colleagues, for being with us. Because you might be surprised that a man is chairing the committee dealing with women's rights and gender equality. Do you have an interpretation? You understand? or I'm not speaking English well. Where is the difficulty? Okay, so it might be strange for some of you to see a man chairing this important committee of European Parliament dealing with women's rights and gender equality, but we in this House, we believe that, paraphrasing Madeleine Albright's words, that there is a special place in hell for men not being in solidarity with women. And it's our obligation, it's our common fight that we should be in solidarity and fight together. So that's why I'm proud today to represent the Women's Rights and Gender Equality Committee and talk about this important topic where I think men should also have a word in that. So, Elena, once again, thank you very much, and I feel honored that I'm accompanied by such wonderful experts and people engaged in this matter. And let me start also by saying that we all know that Europe and no any country or institution is free of violence, also gender-based violence. Is a common issue, and we are all obliged to fight against violence, also the gender-based violence. And speaking about that, I regret that within European Union, and I don't know whether you are aware because I see we have quite a lot of guests, gender-based violence is not being regarded as Eurocrime. So you can imagine that in the catalogue of laws protecting against violence, the gender-based violence is not protected as such. And it's a big mistake because, as Elena said, 35% of women experience physical or sexual violence in their own home. 35%. 95% of women of trafficking victims are women. 95%. 64% of women who are killed die at the hands of an intimate partner or family partner. 64% of women who die, they die because of their partner or the husband. So this is the reality in Europe. And with this reality, we have no legal protection as such, especially targeted on gender-based violence. And of course, many of our countries, including Greece, as far as I know, has ratified Istanbul Convention. And Istanbul Convention is a great tool of Council of Europe, protecting women and girls against discrimination. But European Union as such has not ratified Istanbul Convention. We as an institution, we have not ratified this important tool to combat gender-based violence. And that's why it's so important that we will work on this great proposal of European Commission, and I'm very happy to see that the representative of European Commissioner Helena Dalli is here. Thank you very much for being with us today. That this proposal on directive on combating gender-based violence and domestic violence has been proposed for the Women's Day last year. Thank you very much for doing that. It was very much expected and very much waited. And of course, we as FEMM Committee, we welcome warmly the proposal, the Commission's proposal, and we will be working jointly with another committee, for those who are not from European Parliament, LIBE Committee, which deals with civil liberties and human rights, and we will be working together, of course, on that. We will, of course, try to strengthen the already good proposals which are in this proposal. We don't think it's a final proposal, of course. We think we should work on that. And we have two excellent co-rapporteurs, Francis Fitzgerald, an experienced Irish former Minister for Equality, a champion like Mr. Papadimoulis and Helena and others in fighting for equality, and Evin Incir, who will be from another committee, together working with Francis Fitzgerald. They're both excellent on that. So first of all, of course, the gender-based violence and domestic violence, it's just a manifestation of a structural problem, as we know. It's not a phenomenon which is only in the field of violence, and you can say, well, it doesn't come from this earth. Yeah, it was created because of how we treat women. I come from Poland. And you are, I think most of you are from Greece. I can tell you a lot, and we can share our own experience from our culture and tradition, how women are being treated in our countries. And these stereotypes, prejudices, they influence how we treat girls and women, of course. It doesn't come from another world. It's the hell we created for our mothers, for our sisters, for our daughters, for our grandmothers, for our friends, for our co-workers, female co-workers. This comes from this situation. So what we should put on first is the adequate training, education, sexual education, of course adopted to appropriate age, but the education should be the fundament of every action, and it should include boys and men as well. In this house, me and the Vice President and many of my colleagues, we are having these constant discussions that on this understanding that this is not only women's issue, it's our own issue, and the solidarity of men is very important in this field. So education of boys and men, because we are usually perpetrators. 98% of domestic violence comes from men. So we should be also responsible for that. So what we also should discuss in the context of this proposal is also the issue of stigmatization and secondary victimization. That many women, they have this double victimization, that the prioritization of women's needs should be in the front of our action, that we should look in this directive through the lenses of these women who are victims, and we should address the issues through their lenses, and the stigmatization should be also one of these issue. Of course, what is also discussed is this marital rape. I don't know whether in Greece is a big issue, but in many countries the marital rape is a case. The forceful sexual acts against spouses and intimate partners amount to rape, and this should not be, of course, accepted. And understanding in this context, another context, that the rape, violence is not a private issue. That is our common issue, which influences everyone. It influences not only women, but it influences their children, their family, and has negative impact, not only physical, but also psychological. 69% of women, of the victims of rape, of violence, have negative physical effects. What is also important in the discussion on this directive are the new technologies and the role of new technologies. What I'm talking is cyber violence. The Istanbul Convention is not addressing this issue. It will be a first time when we will be discussing the cyber violence. And thank you for including it in the proposal. So broadening the scope of the definition of cyber violence, including that gender-based violence, cyber violence, should be the issue. 1 in 10 women, according to World Health Organization, have already experienced a form of cyber violence since the age of 15. And of course, the rights, the children rights. It was said by Helena, so I will not repeat what she said. We, as European Parliament, already in 2021, before this proposal, we adopted a resolution on the impact of intimate partner violence and custody rights on women and children. So we have our position on that, which was also repeated by Helena, so I will not go into the details, but it should be also addressed. And last but not least, the data, the way of collecting data by member states, they differ in many member states. It should be also adequately measured to show the scope of gender-based violence and domestic violence. So I wish you a fruitful discussion. We are at the very beginning in European Parliament of the discussion of this proposal of the directive, but what is important is that we hear different partners, that it will be a discussion which will include as many sides as possible, that not only MEPs or European Commission on this official will discuss, but we will hear different voices. So I look forward for this discussion. And once again, Helena, thank you very much for organizing this important event. And I'm afraid I will be forced to leave soon, but I will stay as long as it's possible to hear on your comments. Thank you very much once again.
Ευχαριστούμε πολύ τον Πρόεδρο.
Thank you very much. We are very grateful to the chairman of the FEMM committee for his presentation. It's a great honor and pleasure to have with us today in the European Parliament the United Nations Special Rapporteur on Violence Against Women and Girls, its causes and consequences, Ms. Reem Alsalem. I welcome you to the European Parliament and thank you for accepting my invitation. You work at the United Nations to address gender-based violence is a guide for all of us who are fighting from different positions of responsibility for the same cause. Ms. Alsalem, you have the floor.
Good afternoon, and thank you very much, Elena, for the invitation to speak to you today and to share the stage really with such a distinguished panel of speakers on this important topic. And in fact, I'd like to also commend you and commend the European Parliament more generally for convening a hearing on this important issue, a topic that is actually often under-discussed and which in the best case scenario would actually hardly make it into national or regional discussions, yet alone legislation. And Mr. Biedroń very ably set the scene when it comes to the seriousness of gender-based violence and violence against women in general, and also outlined the efforts undertaken by the European Commission and different European bodies in order to combat that. And this new directive is definitely an important effort that is also exemplary on how to deal with emerging issues of violence against women, but also how to make sure that we are addressing the gaps. And I was very pleased to see, Mr. Biedroń, that nobody flinched when you said you were you were in the function that you were, because indeed, where will we get to if we don't all join forces and if we don't deal together with the issue of violence? And we need, obviously, our male allies in this as much as possible. Now, in October 2022, together with other colleagues of mine, other independent UN experts appointed by the Human Rights Council, I had written to the European Parliament recommending that the directive of the European Parliament and of the Council on combating violence against women and domestic violence explicitly acknowledges the centrality of effective measures to prevent domestic violence against children. This acknowledgement, I should add, is already included in the Council of Europe Convention on the Prevention and Combating Violence Against Women and Domestic Violence, otherwise known as the Istanbul Convention, which is the only international instrument that specifically addresses violence against women. So in this letter that we sent in October last year, we argued that such preventive measures should ensure that in determining custody and visitation rights of children, the history of violence in the family against any of the family members should be taken into consideration, and more broadly also the safety and the security of the child. And in fact, such an approach would constitute an effective translation of the best interest of the child principle, which, as you know, lies at the heart of state obligations under the UN Convention on the Rights of the Child, the CRC, and other human rights instruments such as the European Convention on Human Rights. In fact, so important is the best interest of the child principle that even where the CRC recognizes that both parents have common responsibilities for the upbringing of the child, this responsibility should always be in the best interest of the child, meaning that where it doesn't serve the best interests, we cannot recognize the responsibility of both parents. Now, of course, I know that this is easier said than done. And already, even without bringing any children into the mix, we know from available data that most victims of intimate partner violence are women, and that these women generally tend not to report incidents of domestic violence. And where women victims finally find the courage to report, they run into other set of challenges that render them unassisted and unprotected, often with catastrophic consequences in which they end up further harmed or killed. So why, you may ask, do women continue to be sent back to their abusers and continue to die at their hands? Actually, in many instances, it's down to gender bias towards women, which, when combined with other reasons pertaining to aspects of their own identity, such as their race, could be their disability status, could be their beliefs, could be their legal status in a country, then that experience of violence becomes worse. And discriminatory laws in some countries, many of which are motivated by cultural, religious, and social factors, feed the oxygen that gender bias and stereotypes need in order to persist. It should be clear that these laws are a violation of Article 16 of the Convention on the Elimination of All Forms of Discrimination Against Women, otherwise known as the CEDAW Convention, that calls for the elimination of discrimination in all matters relating to marriage and family relations, including the rights and responsibilities as parents and with regard to guardianship. Now, what may sound as a simple cliché is one of the most important factors that explains the way in which we fail women. Because these gender biases color how judges, police officers, social workers, psychologists, and others tend to hear, understand, perceive, and react to women that come into contact with them, that need their help, including, in particular, victims of violence. And so when that happens, it often results in a massive miscarriage of justice. And as the committee monitoring the implementation of the CEDAW Convention, otherwise known as CEDAW Committee, stated in General Recommendation number 33 on women's access to justice, gender prejudices in the judicial system impede access to justice and contribute to a culture of impunity. So therefore, it's no coincidence that this CEDAW Committee has dedicated a recommendation to states that are parties to the Convention on eradicating gender stereotypes that are based on the idea that either of the sexes is inferior or superior to the other, and as Mr. Biedroń noted, education therefore becomes particularly important in order to eradicate these gender stereotypes from an early age. Now, as a result of these gender biases, mothers find it harder to convince family courts of allegations of violence by their partners against them or their children. And so many mothers then are villainized or accused of deliberately trying to alienate their children from their fathers. This is known as a concept of parental alienation. So they're accused of abusing this parental alienation concept, an offense that may be criminalized in law or in practice in different jurisdictions. So what happens as a result is that women, mothers, lose custody or visitation rights altogether, usually as a form of punishment for having brought up these allegations of abuse to begin with. So in many jurisdictions, it is therefore not a surprise that lawyers in custody cases or divorce cases advise their clients' mothers that they should not bring up these allegations because they may lose their children, even if they're true, mostly when they're true. And so these dynamics often allow parents to be intimidated, coerced, or forced by their abusive ex-partners and then pressured by the courts to withdraw their allegations of abuse and to agree to a specific custody arrangement. Some have had to flee very far from their homes and their countries, which is never a guarantee for their safety. In all of these scenarios, the children are often doubly victimized. Not only have they been witnessing regular violence inflicted on their mothers or on themselves, but they are then re-victimized when courts fail to speak to them in a manner that is suited to them, and when they fail in taking their views into consideration. And often, children are not believed and therefore forced into a situation of contact with the abusive parent. I'm sure we all agree that this is not what a child-sensitive process that places the best interest of the child looks like. My mandate and other regional and international human rights mechanisms have found the lack of attention to partner and child violence in custody arrangements to be a feature in a number of jurisdictions in the European Union, but also worldwide. In fact, I was amazed at how widespread this problem is and how many countries and regions are affected by it. So that is why actually I have decided to dedicate a full report to this at my upcoming session to the Human Rights Council, so in June this year. And the report will try to also outline a number of recommendations. I realize there is no easy fix for this problem, but above all, finding a solution starts with acknowledging that we have a problem and really also identifying the scale of it. So comprehensive and deliberate action is needed that cannot be left to chance. We must be guided by the highest international human rights standards that guide our work and that EU countries also are bound by. So at times it will also require reviewing the implementation of other relevant international human rights legislations that countries are bound by, and ensuring they are applied in a manner that considers the primacy of the safety of parents, family members, and children. So if I can mention just one example, the 1980 Hague Convention on the civil aspects of international child abduction is often activated to return parents that left the country of residence with the children and without knowledge of the other parent. It's interesting, though, to see that a 2015 study of the Statute of the Hague Conference on Private International Law estimated that over 73% of the parents charged in the Hague custody hearings, essentially international kidnapping, are women, and that the overwhelming majority of grave risk cases involve mothers leaving family violence as the taking parent. While courts may use exceptions to return a child if an assessment has been made that the child is at grave risk, these exceptions appear not to be sufficiently activated, considered, or used. And as was also mentioned in terms of recommendations, there is a need to develop mandatory specialized trainings for all those coming into contact with women and children victims of violence. We also need to collect comparable data on the nature and prevalence of intimate partner and other forms of domestic violence, disaggregated by sex and gender, looking at the link of this data to custody cases and strengthening the linkage of that data to the management of custody issues. In addition, the process for accrediting experts such as counselors and psychologists brought on board to assist in drawing up custody and visitation rights must be revamped and must be improved. And finally, I would say, real and effective mechanisms with dealing with complaints about misconduct and conflict of interests need to be put in place when it comes to custody cases and need to be adopted to encourage reporting to and enhance safeguarding. I will close by saying that this is an issue that is really on the radar, not just for me as the Special Rapporteur, but really for all international and human rights mechanisms that I know of, from CEDAW, from GREVIO, even MEP, which monitors the implementation of the Belém de Paro Convention, because we really see the link of this to violence against women and being an extension often of coercive control and of domestic violence and intra-partner violence. Thank you very much.
We warmly thank the UN Special Rapporteur for her excellent statement. Combating violence against women and domestic violence is part of the European Commission's work to protect the EU's fundamental values and ensure respect for the rights enshrined in the Charter of Fundamental Rights. The Commission's proposal differs from the Istanbul Convention, the most comprehensive international framework in this area, in that it sets minimum standards for EU member states within the EU's areas of competence, including the criminalization of offences of online violence not specifically covered by the Istanbul Convention. For the first time, EU-level rules are proposed to combat violence against women and domestic violence. We therefore welcome the directive as a first step in the right direction, and rest assured that we will do our best as European Parliament to propose amendments to improve it. At this point, I would like to thank Mrs. Lesia Radelicki on behalf of Commissioner Dalli for accepting my invitation. Mrs. Radelicki is the Gender Equality Officer in the Office of the Commissioner Dalli, with long experience in the field, and she will present to us the proposal for a directive on violence against women and domestic violence. You have the floor.
Thank you, Madam Chair, for the invitation, but also for your engagement on combating gender-based violence. And I will join the praise that others have already given you, but also your political group and the Parliament as a whole in engaging on this issue and in supporting us in this work, because I think that without the European Parliament, we might not get as far as we would like to. So thank you very much. Indeed, I mean, we've heard the numbers that have been put forward on the seriousness of the issues, so I will not repeat them, but also the importance politically that this issue has. The President of the European Commission, when she started her mandate, that's one of the things that she said: I will do everything I can to combat violence against women and domestic violence. And so with those two elements in mind, and sadly enough, when we started the mandate with Commissioner Dalli, we very quickly faced the pandemic, and saw that actually violence against women and domestic violence was going up. So it was very clear to us that we couldn't longer wait, and we had to act. Now, this said, well, there was the Istanbul Convention indeed, but also if we look at member states, all member states have dealt with combating violence against women and domestic violence in one way or another. And also at European level, there are 14 pieces of legislation that refer to combating violence against women and domestic violence or promoting gender equality in one way or another. So what we wanted to do is to make sure that everything is actually in one document and that we actually live up to international standards like the Istanbul Convention, that we could act with our own proposal and at the same time to make a difference for women and those that are victims of domestic violence on the ground. So that's why we came forward last year with this proposal. Now, let me walk you through this proposal. What is the novelty with this proposal and how did we want to make a difference? First of all, we wanted to make sure that we were going to criminalize certain aspects of violence against women and domestic violence. That's why in the first chapter, and we've based ourselves on the legal basis, Article 83(1), meaning anything that is sexual exploitation of women and children, and the other aspect that is computer crime, to write our proposal. So what we did in the first chapter is to identify a series of violence against women. The first one is rape. Now, rape is criminalized in all member states in the EU, so there is not the novelty. The novelty is that we actually introduce the element of consent. So by introducing this element of consent, we are bringing a novelty, legally speaking, at European level. And I'm stressing this article because, and I'll come back later at where we stand with this directive, but this is an important article that we need to make sure that we will get that article until the end. The second element that we've criminalized is female genital mutilation. And then we added a whole series, and this was also mentioned before, crimes that are related to online violence. And indeed, that's where we go broader than what the Istanbul Convention is putting forward now. So I'm thinking about online harassment, hate speech online, illegal sharing of images without consent, and so forth. The rest of the directive is actually based on the Istanbul Convention because for us, the Istanbul Convention still remains the gold standard. And while this is its own convention, we are pushing for it to be ratified at EU level. We also used it in our own directive. And so the other chapters in the directive follow the same logic as the Istanbul Convention. So the third chapter that is on protection of victims and access to justice, what we tried to do with that chapter was that we know that women, there is still an underrepresentation of reporting of women that are victims of violence against women or domestic violence. So we wanted to put forward systems that allows to make this step lower and to make it for victims easier. By, for example, having a one-stop shop where women can go and report it, be protected, and so forth. But also to give, for example, equality bodies the possibility to speak on behalf of victims, to have officers and authorities that are better trained in order to identify the types of the types of violence that has happened in order to direct the victims to the right support afterwards. So that's in terms of just a few examples of what we did in access to justice. Then the fourth chapter is about the support for victims. Why is this an important chapter? Is because although at EU level we have already a general directive, that is the Victims' Rights Directive, what is clear is that for victims that are victims of violence against women and domestic violence, you need specific support, specialized support. We're thinking of victims of sexual violence, we're thinking of victims of FGM, of sexual harassment at work. What we also put in that chapter is, for example, the helplines with a harmonized EU number, so that a woman, no matter where she is in the EU, she can always call the same number. Now, I know there are countries that have already good examples, and they have already a good helpline that exists, and so this would work together. So we're not reinventing there where it's working, a new number. We just want to make sure that those member states that don't have a number that is working 24/7, that is free of charge, and that directs the women to the right help, that they actually put forward the necessary mechanisms in place. And this is, technically speaking, already put in motion at EU level. We also want specific support for victims that are at greater risk of violence. I'm thinking of, for example, women with disabilities, women, migrant women, women of minority backgrounds, or even women that are fleeing zones of conflict, like we have seen with women fleeing Ukraine and coming to the EU. There, I would also like to highlight the fact that we have specifically put forward 3 chapters related to the support and the protection for children. And it has been already said here, the importance of making sure that children's best interest is being put forward, and so that also when custody is given to them, that their best interest is taken into consideration. And if you look under Article 33, that is specifically on the support of children, it's talking about adequate support, it's talking about age-appropriate medical care, emotional, psychological, and educational support. But it also talks about, for example, interim accommodation, how this should be taking children's rights into consideration. And then Article 34, that is specifically about the safety of children. There we talk about the fact, and I will read it out, that member states shall establish and maintain safe places which allow a safe contact between a child and the holder of a parental responsibilities who is an offender or suspect of violence against women or domestic violence. And further on it says, by also keeping the best interest of the child. What we also did in those chapters is by saying that children that are witness of violence are also considered as victims of violence, which I also think is an important part. So that's in terms of victim support and specifically on children's rights. Then what is also very important is the prevention part. And in terms of prevention, it's important to train and inform those that work closely with victims. And that goes from the medical care to the psychological support to authorities to police forces. But also we added an element of media, because the media can sometimes also play an important role in the images and the messages that they project. And then the final chapter is about another point about prevention that I would like to mention, and because the chair of the FEMM committee said the importance of working with men, there we also felt that it's important to have programs in place that work with men, but also with the perpetrators, so that it doesn't always only fall on the shoulders of women, but that we actually tackle it at the basis of the problem, those that are causing the violence. And then the last chapter, we've heard it here as well, the importance of collecting data so that we know what the situation is, so that we can analyze it, and that we can put forward policies that are adequate and to the point, as well as coordinated between different services, but also between different member states. So that's where we are. That's what we did with this proposal, and that's what we hope will make a difference for women on the ground. Indeed, that was put forward last year in March. The Parliament has started its work, and we're looking forward to its report later this year. The Council is doing the same at the moment. They're also working on their position, and hopefully once both institutions have finalized the positions, we will be able to start negotiations. But we will continue looking forward to the support from the Parliament. You are a great partner to us, so thank you very much, and good luck with your reports.
Ευχαριστώ θερμά την κυρία Ραντελίκη για την παρέμβασή της. Ένα από τα βασικά ζητούμενα παραμένει η ανάγκη να κυρωθεί άμεσα από την Ευρωπαϊκή Ένωση η Σύμβαση της Κωνσταντινούπολης.
I would like to thank Mr. Radelicki for intervention. One of the key issues remained the need for the European Union to ratify immediately the Istanbul Convention, the first binding legal instrument of its kind to address and prevent gender-based violence, protect victims and punish perpetrators. The Court of Justice of the EU in October 21 ruled that even without ratification by all member states, the European Union can ratify the Istanbul Convention and must do so immediately. Member states that do not consent or delay cannot therefore hold the European Union hostage on this crucial issue. I would like at this point to welcome Mr. Biljana Brankovic, member of GREVIO, the institution of the group of experts on action against violence against women and domestic violence, who monitors the implementation of the Istanbul Convention. She will analyze how the Convention is implemented by the Member State, and especially the Article 31 concerning the rights of guardianship, contact with the children, and the right and safety for the victims or for the children. Ms. Brankovic, you have the floor.
Thank you very much for the invitation, Kountoura, and also for all your efforts. I'm a member of GREVIO for 8 years, and I would like to underline that GREVIO published 27 baseline evaluation reports so far, so we have extensive findings on the issue of custody and visitation. But please also note that GREVIO does not have and will not have an official position on EU directive, because this goes beyond our mandate. We cannot take an official position on any national or international policy development. I will present a brief overview of the implementation of Article 31 of the Istanbul Convention in 17 EU countries, which are state parties to the Convention. We still need to conduct our baseline evaluation on 4 EU countries, including Greece, so please note that Greece is not included in the overview I'm going to present today. I will rely on midterm horizontal review of GREVIO baseline evaluation reports. You are probably familiar with this publication, but I will also cover our latest reports which are not included in this publication. The first interesting finding I would like to share with you, you probably know that GREVIO in its recommendations uses 4 levels of urgency. When the recommendation starts with the verb urge, it means that this recommendation is regarded as priority number 1. In our reports on 17 EU countries analyzed so far, all our recommendations on custody and visitation start with urge, with the exception of Austria. I believe this very fact is revealing. My point number 1, it is interesting that GREVIO found in its baseline evaluation that some EU member states do not have in their respective legislation the explicit reference to domestic violence or other forms of violence against women as the legal criterion to be taken into account when deciding on custody and visitation. For example, Italy, Belgium, Cyprus. In Cyprus, granting of shared custody is the norm, including when a child witnessed violence, and there are no examples from court practice that episodes of domestic violence have led to limiting of custody or visitation rights of the abusive parent. Further, some EU members do have a legal basis to prevent granting of parental responsibility, including custody and visitation rights to abusive parents, but I highlight here, GREVIO concluded that these relevant provisions are very rarely applied in practice in these countries. For example, in Austria, Finland, France, the Netherlands, Portugal, Spain, Sweden, Romania, Estonia. Just an example, in Spain, provisions in the Criminal Procedure Code regulate the modalities for the suspension or limitation of parental authority as a pre-trial protective measure. Further, the famous Spanish law on gender-based violence offers judges in proceedings under this law, and I quote, to suspend parental authority, guardianship or custody of alleged perpetrators of intimate partner violence, and also allows, I quote, to suspend or regulate visiting rights of alleged perpetrators. Criminal judges in Spain, however, are particularly reluctant to suspend or limit parental rights, both in pretrial rulings and in final sentences. GREVIO therefore wrote in its report on Spain that it notes with satisfaction the applicable provisions in the Spanish law, but regrets its limited use in practice. Another example, in a report on Romania, GREVIO noted that shared custody is the general rule and exclusive custody is extremely difficult to obtain, even if psychological expertise proves the negative effects of witnessing domestic violence on the children in question, and unsupervised visits with the abusive parents are granted. In several EU member states, there is no express obligation to ensure that incidents of violence covered by the Convention are taken into account in determining custody and visitation rights, but there are some provisions in respective laws that offer the possibility of limiting such rights. For example, in Poland, Germany, Slovenia. However, again, GREVIO concluded that these provisions are very rarely applied in practice. My second point, relevant professionals are often not aware of harmful consequences of witnessing domestic violence on children, and they are not sufficiently trained on domestic violence. These factors contribute to bias in custody and visitation decisions. Witnessing violence against the mother may have damaging impact on children, including long-term consequences such as depression in adulthood. This is confirmed in research, which GREVIO often quotes. But the lack of awareness among judges and other professionals is linked to another relevant issue, which is how the courts and relevant professionals interpret the best interest of the child. GREVIO noted that many state parties to the Convention tend to give priority to the presumed best interest of the child, which is deemed to be to maintain contacts with both parents at all costs, regardless of the violence children have witnessed. To clarify, GREVIO, of course, acknowledges the right of the child to maintain ties with both parents, as specified in the Convention on the Rights of the Child, but highlights the need that all relevant professionals, especially judges, take into account and recognize that witnessing violence against a close person jeopardizes the best interest of the child. I will provide more examples how this best interest of the child is interpreted in court practice. For example, in Austria, France, Italy, Portugal, and Spain, GREVIO noted that the joint exercise of parental authority was generally maintained even in case of a final criminal conviction for violence committed against the other parent or where a protection order was issued. As an example, in France, legal provisions allow for withdrawal of parental authority as a child protection measure when one parent is convicted of violence committed against the other parent, or independently of any criminal conviction, by a civil judge when the child witnessed psychological or physical violence by one parent against another. However, in practice, the withdrawal of perpetrator's parental authority remains exceptional in France, even in the case of the final criminal conviction, despite the persistent danger to the mother and the child. In Italy, GREVIO noted that children who witness domestic violence are not protected, even in cases where the violence has led to sentencing or other measures, including protection orders against the perpetrator. Moreover, civil courts in Italy and court-appointed experts not only fail to detect instances of violence, but tend to ignore them. In Slovenia, GREVIO noted some cases that children who were victims of domestic violence were obliged to have contact with their abusive parents against their will. Although applicable legal provisions provide an obligation of judges to take into account the opinion expressed by children in proceedings concerning their interests. Therefore, in many reports, for example, on Portugal, Sweden, Austria, Romania, Slovenia, GREVIO highlighted a lack of understanding among judges and other professionals of the harm experienced by children due to witnessing domestic violence. So, GREVIO repeatedly recommended appropriate training for judges and relevant professionals, and also the need to introduce guidelines for judges and other professionals, and also the need to improve expertise of court-appointed experts. In Malta, just an example, GREVIO noted the lack of expertise on violence against women among court-appointed experts. GREVIO also referred to cases where children were killed in the context of unsupervised or even supervised visitation by the father who previously abused their mother. For example, in reports on Italy and Spain. In the report on Spain, GREVIO mentioned the case of Ángela González Careño, this case was brought before the CEDAW committee under the optional protocol. Her daughter was killed by her father during the unsupervised visit in spite of the history of intimate partner violence against Ángela. My next point. In many reports, GREVIO warned against the use of the concept of parental alienation and similar concepts, including its use by court-appointed experts, and also noted that these concepts lack scientific foundation. For example, in reports on Germany, Poland, Spain, Italy, Romania, Belgium, France, Estonia, and Cyprus. We repeatedly and consistently, and this was done on my initiative, if I may add, quoted the statement of the European Association for Psychotherapy, which highlights that concepts such as parental alienation syndrome or parental alienation should not be used in psychotherapeutic practice. This statement serves as a guideline for European psychotherapists, since this association includes 128 organizations of psychotherapists from 41 countries. My next point, the use of mediation in the context of separation proceedings and bias towards victims of violence has been noted in some of our reports. We noted that victims of domestic violence wishing to separate may be required to undergo mediation as a first step, and this procedure can be decisive in determining custody and visitation rights. For example, in Denmark, separated parents who do not agree over custody must attend a joint meeting mediated by state administration with the aim to reach a mutually acceptable decision about child custody, residence or visitation rights. These meetings are not formally called mediation, but GREVIO assessed that such meetings may be seen as equivalent of the mandatory mediation, which is banned under the Convention, since in practice any refusal to attend can have negative consequences for the party which refuses. Now just try to imagine how that woman must feel. GREVIO made clear that such practice in Denmark must end and recommended that the authorities should recognize the power imbalances in violent relationships and ensure that parents with a history of violence are granted separate meetings with the state administration. GREVIO also noted a worrying trend that bias against women who raise issues of domestic violence in proceedings related to custody and visitation, for example, in Denmark and Italy. In Italy, civil courts and court-appointed experts often require victims to meet their violent partner to reach a friendly agreement on custody and visitation. Victims are often declared as uncooperative or unsuitable as parents. In Sweden, GREVIO noted, based on interviews with social workers, that they do not question parental abilities of abusive fathers, but widely accept the notion that an abused mother is unfit to fully care of her children. Next point, in some countries, GREVIO noted that family and criminal courts do not sufficiently coordinate and do not consult all relevant professionals or do not screen cases related to determination of custody and visitation for domestic violence. In Italy, Malta, Cyprus, just an example, GREVIO found that family courts do not coordinate with criminal courts when taking decisions on custody and visitation in order to check, for example, if criminal proceedings against the father of the victim's children are pending or were brought in the past. In Cyprus, Portugal, Italy, Estonia, and Slovenia, GREVIO thus recommended that family courts should consult and coordinate with law enforcement, health and education institutions, and, I underlined, with specialist women's services, in order to take into account any episodes of violence that previously happened. Judges do not systematically screen cases related to custody and visitation for domestic violence, as noted in GREVIO reports on Portugal, Italy, France, the Netherlands, and Romania. Another problem, GREVIO also noted shortcomings related to supervised visitation in some countries. For example, lack of necessary resources or infrastructure to ensure safe supervised visitation was identified in Malta, for example, where GREVIO noted that the lack of adequate infrastructure meant that victims had to wait in the same waiting area as the perpetrator, therefore endangering the physical safety and psychological well-being of victims and their children and perpetuating the cycle of power and control. GREVIO also noted serious shortcomings in training of professionals responsible for supervised visitation, for example, in Austria, Malta, Slovenia, Spain. Finally, I would like to refer to the joint statement on custody and visitation, which was issued several years ago by the Platform of International and Regional Independent Mechanisms on Violence Against Women and Women's Rights, including CEDAW Committee, UN Special Rapporteur on Violence Against Women, GREVIO, and sisterly monitoring mechanisms in Latin America and Africa. In this joint statement, it is clarified that abusive relationships between parents predominantly affect women and they have direct impact on the children's life, yet violence against women is rarely considered as a relevant factor by national authorities in child custody decisions. It is further stressed that a holistic and coordinated approach based on the existing international and regional standards must be applied at the national level in such cases, not only to uphold the principle of the best interest of the child, but also the principle of equality between women and men. This joint statement also warns against the use of the concepts such as parental alienation and similar. So it is concluded, and this is my final statement from this joint statement. Accusations of parental alienation by abusive fathers against mothers must be considered as a continuation of power and control by state agencies and actors, including those deciding on child custody. Thank you very much. Evcharistopouli.
Thank you very much, Mrs. Brankovic, for this analysis and the data you have presented to us. There are several things to be corrected in many countries and things that are missing and need to be corrected in order to solve the issues of custody or joint custody in such relationships. Actually, the next speaker will be our comrade and friend Irini Agathopoulou, Member of Parliament of SYRIZA Progressive Alliance and first Vice Chair of the Special Standing Committee on Equality, Youth and Human Rights of the Hellenic Parliament. Mrs. Agathopoulou has fought hard in the Greek Parliament to defend the rights of women and children, and especially during the passage of the law on family law in Greece, which has been in force for a year now, introducing compulsory joint custody in order to highlight the tragic consequences of the application for. So she has worked several things. We have a very close and constructive cooperation, and I'm very pleased that she's here with us today. You have the floor, dear Mrs. Agathopoulou. Thank you, Helena. Thank you, dear Mrs. Kountoura. I would like to start with my sincere congratulations to dear friend Elena Kountoura. She has helped a lot to this issue of gender violence and gender equality. She has contributed a lot also ourselves in Greece in order to illustrate these problems. It is also a very big honor to be here along with the rapporteur of the UN, the president of the Committee of Gender Equality and Women's Rights, and of course to be here with all the special guests. As a member of the Greek Parliament and first Vice President of the Committee of Gender Equality, I would like to talk today about the situation in Greece right now. After the changes in family law a year ago, when some laws passed by the actual government, the right-wing government. As you may know, in the autumn of 2021, the Greek Ministry of Justice, under the pressure of a very well-organized lobbying of famous fathers, did some changes in family law with regard to joint custody, independently of the gender violence, without taking into account the Convention of Istanbul. The law was voted only by the government party and not all the MPs, because there were some strong reactions by members of the Hellenic Parliament and also by the Amnesty International or the or several other international and European organizations. Let me underline that during the consultations, the minister refused to see any women's organization, while he accepted to see all the strong and powerful organizations of fathers, let's say. A year after the ratification, all the arguments of the Ministry of Justice that the law would help to solve in a better way family matters, well, was proved to be wrong. This law actually had the opposite result. The violence between families, among families, was increased, and the number of cases in Greek courts has increased radically. It is actually the announcement of the Athens Bar Association that the time of obtaining a temporary injunction has been extended from 2 days to 15 days due to the huge increase of family disputes. In the same way, the number of disputes before the criminal courts between spouses with successive opposing lawsuits has also increased excessively. In addition, there has been a sharp increase in domestic violence and the number of femicides, which in many cases are related to the ban of women's movement, which is one of the most unfavorable new provisions of the law, especially for women living in abusive environments. So, in September 2022, we had the killing of Anna and her baby in Kavala. This is a femicide that it is strictly connected to this law. Every day we're informed about mothers and children who, despite reporting domestic violence, cannot be protected because no restraining orders are immediately issued to remove the perpetrator from the family home, while they are obliged to inform the perpetrator of any change in the child's place of residence or school in order not to be accused of parental alienation, as it has been actually relationship breakdown, it has been renamed, in order not to blatantly violate the recommendations of GREVIO. Every day, court decisions are issued which, in violation of Articles 31, 26 and 45 of the Istanbul Convention, refuse or fail to take into account the exposure of children and women to domestic violence and disregarding the additional risk they will be exposed to due to the application of inappropriate parental care arrangements, custody and contact arrangements, provide the perpetrator with an access and control over the lives of his or her victims without any measures to protect and safeguard the best interests of each child. Unfortunately, the current leadership of the Ministry of Justice has shown that it has clearly punitive towards women mothers who have suffered gender and domestic violence. So, in the law on child custody, which is currently in force, the following apply. Joint and equal parental custody is the rule that applies by default to all children when their parents are separated. In the case of a different parental agreement or court order, there is the parent with whom the child resides and the parent with whom the child does not reside. So, it is the law only confers rights on the second parent and only obligations of the first parent towards satisfying the rights of the other parent. The term alternative residence, while originally present, has disappeared. Now, breakdown of relationships with the other parent and family members replaced the term parental alienation, just in order to avoid reactions. Domestic violence is completely ignored, and the victims, children and non-abusive parents, mainly mothers, are exposed to a greater risk than they were already exposed to. The first version of the bill did not include any reference whatsoever to domestic violence, and only due to strong protests from NGOs and women's organizations, domestic violence was finally included in the law, but in a completely unacceptable way. Parental rights and contact with the child may be restricted or terminated only after the parent has been convicted of crimes against the family, violence or crimes against sexual freedom or crimes of economic exploitation of sexual life. In reality of Greek courts, this means that all offenders have unimpeded access to all of their victims for more than 2 to 5 years. Furthermore, it is not clear whether a father's conviction for domestic violence against his mother or one of his children is intended to result in restrictions on contact with all children. Other problematic aspects of the Greek law through which joint custody became mandatory for all children in Greece are the following. The child is approached from the perspective of a deeply patriarchal society, as a passive recipient for the exercise of parental rights and not as a rights holder. The law is indifferent to the best interests of the child, which are not accessed for each child individually, so there is no, there is a common rule for all children, all cases. In addition, the will of the child is not taken into account. We also see an increasing tendency for perpetrators to accuse mothers of violence, of making false allegations or reports of violence against the children in order to alienate them from fathers. Even worse, we are seeing a growing trend of court orders removing custody or parental custody of children from the abused mother on the grounds of parental alienation. All of the above are unacceptable in a country that has ratified the Istanbul Convention and claims to be fighting to eradicate gender-based violence. My speech here today is a cry of anguish from the victims of domestic violence, women and children, and from all women's organizations. And because today in Greece we are facing another very serious development, the Ministry of Justice has set up a new legislative commission to reform the institutional framework of dealing with domestic violence, with the aim, according to well-funded leaks, because ourselves, MPs, were not formally aware of the facts, so of giving legislative recognition to the term parental alienation. We believe that it is more important than ever that the directive to be drafted in the near future by the European Parliament and proposed to the national parliaments for adoption in order to eliminate current legislative distortions and to contribute substantially and effectively to the treatment and prevention of all forms of gender-based violence. So we demand family courts. They do not exist in Greece right now. We want them to have psychologists, social workers, and well-informed judges. We want the application of Article 52 of the Istanbul Convention, issuing restraining orders immediately after a report of domestic violence to remove the perpetrator from the family home and prohibiting contact with victims in order to prioritize the safety of victims. We also ask for immediate implementation of the recommendations. They are just recommendations, but they need to be implemented, GREVIO recommendations, requiring a ban on the use of, in a judicial context, of concepts and terms referring to parental alienation of the violent parent, which is attributed to the non-violent parent who reports domestic violence. Educate judges, prosecutors, experts, and social workers on how perpetrators of domestic violence use the conceptual construct of parental alienation, which has been rejected by the scientific community for decades now, in order to deconstruct reports of domestic violence as false and blame the mother as an uncooperative and unfit parent who is responsible for the child's poor relationship or refusal to communicate with an abusive father. A strict application of Article 31 of the Istanbul Convention in all family law cases in which there are indications or reports of domestic violence, regardless of the existence of a criminal complaint against perpetrators. Because the future we must create should be a life free of violence for all children. Thank you very much for your attention.
Irini, σε ευχαριστώ θερμά για τη στοχευμένη εισήγησή σου.
Irini, thank you very much for your target contribution at this point, because you mentioned all the problems concerning these legislation that were voted last year, and we can see how these laws do not abide by the Istanbul Convention and also work to the detriment of the victim of family violence. Now I would like to hear more about the women organization point of view, and I would like to call Marcella Pirrone from the network WAVE, and she will give us an insight from the field and give us the perspective, the role of women, and she will also highlight the challenges posed by the proposal for a directive on violence against women and domestic violence. WAVE was one of the largest women organizations and has more than 164 members in 46 countries.
Thank you very much, Madam Miss.
Personally,
and in the name of WAVE, because we know your very great commitment and important commitment on the issues of violence against women and domestic violence, and this made this event possible today. I feel very honored to be able to participate and represent the vast world of women NGOs active in the field, all the members of the European network WAVE, and I thank all the speakers and those who participate. It's a great opportunity to listen and to learn from all of you and your expertise. The fertile encounter between politics, institutions, and the women's civil society is crucial in order to tackle such global serious problems, and today's event is a very good example for this. The contamination between our practices of feminist activism in the field of the human rights of women and their children, our passion and competence, our ability in our everyday work at the forefront to give voice to every single woman and child who asked for a life free from male violence and gender-based violence, our strong advocacy effort. This contamination with the responsibilities and competences of committed policymakers and national and international institutions has in the past and today brought visible results. Today, civil society, feminist society, is more and more competent and active in its advocacy in front of all national and international institutions and human rights mechanisms and courts, and in coalition and in cooperation with politicians. Women WAVE, the Women Against Violence Europe network, represents, as has been said, 164 members and with more than 1,600 women specialist services in 46 European countries, and strongly believes in civil society role and strongly strives for ever better responses to violence against women and girls and domestic violence. Regarding the directive, WAVE acknowledges the attempt to create a dedicated EU legal instrument to develop a coordinated approach to protect women and children from violence against women and domestic violence, trying to harmonize EU law with established international standards, and to move this area forward in the member states that have not yet ratified the Istanbul Convention, especially, but not only. WAVE supports every effort in this direction and strongly wishes a joint and equal effort for progression of the Istanbul Convention accession by the EU and ratification by more states and this proposal. They have to go together, and they have to integrate together and somehow enrich every instrument and every answer we can give to this problem. WAVE appreciates this commitment of the Commission and of the European Parliament. However, there are some shortcomings which we wish to point out. First of all, violence against women and girls is not defined in the draft as a human rights violation, having rather preferred a high criminalization approach. There would be a lot to say about this. It's not to see it here, but a high criminalization approach has proved in many states not to be the right approach, not to be really preventive. Second, the recognition of the role of women's organizations and women's specialist services in the text of the directive is, from our point of view, weak at best. WAVE is concerned about the absence of a proper definition clearly distinguishing generic from women's specialist support services to safeguard the specific mission, approach and quality standards of each service. Built on a decades-long feminist and gender-responsive expertise, women's specialist services is a collective term used to define feminist services that support women and their children experiencing gender-based violence. These services include, but are not limited to, women's support centers, shelters, helplines, rape crisis or sexual violence referral centers, and primary prevention services. Women's specialist services empower and support women and girls throughout the whole cycle of violence by putting their needs and safety at the center of all interventions, applying an international intersectional approach and working together with them, recognizing their agency, dismantling the barriers women and girls experience when seeking access to support, creating a safe environment. Women's specialist services are agents of social, cultural and political change, promoting women's equality and challenging the patriarchal system, which is the root cause of violence against women and girls, as we know. In our view, the chapter on victim support does not specifically or enough distinguish generic victim support services and women's specialist support services, leading to an inaccurate interpretation of the comprehensive support options needed for victims of violence. Women's specialist services have proved for decades to be best equipped specialist support for women, for victims of violence against women and domestic violence, thanks to their approaches and competences. They are highlighting in this occasion the concerning impact of violence on child custody, and they have done this since decades. It's not for WAVE, it is not a new problem. I remember a worldwide conference in 2005 where WAVE presented a research among its members how this was already becoming a problem when shared custody discussion was coming up. Therefore, the provisions regarding women's specialist service in the draft directive must contemplate the need for cooperation and coordination between services, including clear referral pathways between generic victim support services and women's specialist support service, within a comprehensive framework of support. A few comments specifically on the directive and child custody. With regards that the impact of domestic violence on women and children is not clearly mentioned. In the draft, there is no clear provision that this has to be seriously considered in custody and visitation rights decisions. It was to expect to see the European Parliament resolution, which has been quoted, adopted in October 2001, on the impact of intimate partner violence and custody rights, and it was expected, as it was passed with a large majority, that it would be considered more in this draft, and that it would be taken more into account when it comes to child custody issues. The same would have been expected about the provision of Article 31 of Istanbul Convention. So this has to be considered and amended from our point of view. WAVE has already provided the European rapporteurs last autumn with its written amendments to every article, like many other of civil society and organizations, and we will integrate by given deadline, which is the end of January, the report by the Special Rapporteurs Inshir and Fitzgerald in a detailed format as comment to relevant articles. So for today's discussion, I can only recall and highlight some main considerations and suggestions. We have to consider the continuum of violence intimate partners violence and violence against children are interlinked phenomena, as we heard. Child custody, access, contact, and visitation arrangement are often the only way for the abuser to maintain control of the victim after separation or divorce. It's well known that the post-separation phase is a particularly dangerous and risky moment. There is risk of reiteration of violence, including the risk of femicide and infanticide. We have more and more children who are killed in this phase by partners. The killing of women and children is a real, very worrying and concerning problem. WAVE therefore highlights the need to include in the preventions chapter of the directive an explicit provision establishing the link between violence against women and domestic violence and child custody, as well as visitation rights, as part of the protection, support and prevention measures. A provision of which should oblige the member state to ensure that violence by an intimate partner is a factor to be considered when determining custody and visitation rights. We have heard best interest of the child, protection of women and children from violence and best interest of the child must be paramount, as we hear from Istanbul Convention, from UN Convention of the Rights of the Child, and should always take precedence over other criteria when establishing the arrangement for custody and visitation rights. In the context of custody proceedings and visitation rights in cases of domestic violence, significant shortcomings have been identified in legal proceedings where bias in defining the best interests of the child are very common. I will talk at the end about the context where this is all applied and how important the context is in terms of interpreting laws. More precisely, state parties tend to prioritize maintaining contact with both parents, as we heard, at all costs, regardless of the violence children have witnessed. Disregarding the experiences and needs of children who suffer physical and psychological harm is a serious breach of children's fundamental rights. The failure to recognize and address incidents of domestic violence in determining child custody and visitation rights is a violation of the right of women and children to life without violence, and it's incompatible with the best interests of the child. The history of violence in partnership has to be considered. It has to be guaranteed that the custody and visitation rights do not jeopardize the rights and safety of the victims, both the non-abusive parent and the children. This should ground the basis for making, reviewing, and executing related decisions on child custody and visitations decisions. We can never repeat that enough. The best interest of the child principle should be interpreted in the context of rights, safety, and protection of the victim. The right to live in a safe and peaceful environment should be directly linked with women's rights to live from violence. We've also, and we have heard now with concern what is happening in Greece, but it's not only Greece, opposes to mandatory shared custody, as each case has to be ruled individually based on what is the best interest of the child. That's the task, that's the duty of whoever takes care and decides about custody. They have to look at the single situation. They have to examine with competence what is the proper situation. They can't go on with mandatory general shared custody without checking, especially when women and the mothers are really alarming all the authorities. So it is defined that this best interest of the child has to be interpreted as defined in UN Convention on the Rights of the Child. And we have all to make a big effort, and we will see about what is meant also with risk assessment in terms of common effort. Even more, this has to be done in cases with a history or an indication of violence. Shared custody decisions should be postponed until adequate investigation and adequate risk assessment has been carried out. Safeguards for the best interest of children, the directive provides for the possibility of, and it has to do it more strongly, the possibility of adjusting, restricting or withdrawing parental responsibility in cases of violence against women, if necessary, of an emergency basis. The directive should ensure that the views of the child are given due weight in relation to such custody or access rights. Member States shall establish and maintain safe places for safe contact between a child and the holder of parental responsibility, who is perpetrator or suspected perpetrator of violence. Insofar as the letter has access rights, and we were very concerned about the wording in the draft, where there is, where we find again the right of the parent, instead of talking about the right of the child to a safe parent. So a concept which we had fought against for decades and who had been finally cancelled now is coming up again in a European draft. This is really concerning. Risk assessment is very, very important, and in order to ensure comprehensive and appropriate support and protection to victims, a standardized approach to risk assessment that promotes a shared understanding of risk across the system and a common language to communicate risk must be adopted. All competent authorities should be involved in assessing the risk for victims, including the consideration that suspects charged with minor offences are as likely to be dangerous as those charged with more severe offences. There can't be, again, an automatic mechanism, especially when we are in cases of domestic violence and stalking. Specialized training, we have to be very careful, it has been mentioned today. Specialized training for frontline professionals on the use of risk assessment is essential, but not only. The training has to be generally in increasing the competence on the problem of domestic violence and violence against women, because it has its dynamics and its mechanism, and it has to be recognized in time and duly. Multi-institutional training, training by a variety of institutions and civil society experts. This is very important. There has to be more points of view. We have to diminish the risk of influence of lobby groups in the trainings, which we have seen increasing more and more by certain movements. Trainings must become mandatory and stable for all personnel in justice, in law enforcement, in forensic, in psychological, social services, and healthcare professionals. Only this way certain bias can be prevented. The increase, for example, the increase of the use, assertion, acceptance of non-scientific theories and concepts in custody cases which punish mothers who attempt to report cases of child abuse or gender-based violence by preventing them from obtaining custody or by restricting their parental rights. I will conclude by talking about the context this draft is coming, and why I want to do this is because every law, even if it's the best written law, has to be implemented and will be effective depending on the cultural and the competence ground it is implemented to. Otherwise, in the best interest of the child is a very good example, everyone can interpret what is best in its own interest. And so the best interest of the child can be interpreted as its best interest by a perpetrator as well as by a parent who cares for the child. So we have to consider the context, which is now, and that makes us understand better why WAVE fears that there might be the danger of a failure in the implementation and effective protection for women in situations of violence, even with this directive, if we are not really working together and working on the culture and training. Starting what we have heard till now, with NETBO can only confirm strongly, with more than its 30 years of experience, what, and I'm allowing myself to quote the estimate, Special Rapporteur Alsalem, because I really recommend to read what has been written in the introduction of the call, which in December was sent out by the Special Rapporteur, because those few pages are very, very effectively describing what women and children have to go through. It's, WAVE absolutely can confirm all this, and it was also, as we have heard, voiced already 2019 by the platform of these independent experts. It is describing very clearly the ordeal that women and children have to go through on their long and arduous path out of an abusive relationship with a violent partner and father. So it's it's not only coming, what is described there, and I want to stress this out, from biased women and feminist association. It's evidence-based, it's coming from an international special rapporteur, international guaranteed mechanism, and it's really referring to cases, researches worldwide, and illustrating with great precision and competence the many aspects of this problem. And I would like also and it's showing how mothers are being blamed for the situation by professionals. They are even blamed for being victim of a violent situation, of having chosen a violent partner, of having stayed in this violent relation. They are blamed by all professionals, and they see even her parental skills questions, her opinion dismissed, with denial of the violence to which she and children are subjected. Often, such claims make mothers paradoxically responsible for failing to protect, with an unacceptable reversal of responsibility for the abuse and negative judgment of their parental capacity, with children being forced, against their expressed fear and concern, to have contacts with violent fathers. I recommend also a recent interesting research, which I know has been delivered to the Special Rapporteur in this consultation, by a research group of a Canadian university in Ottawa around Professor Simone Lapierre, who has very interestingly interviewed children, many children between 12 and 17, so it's really young people rather than children, who are absolutely capable to express themselves and their feelings. And they, in this research, they tell how they experience not having been taken seriously and having been labeled by all professionals as alienated by the mothers in custody cases, instead of really being taken for what they were saying. So hence, WAVE calls on the European Parliament and national decision makers to acknowledge the relationship between victims, perpetrators, and children and their wider social environment. Violence continues, as we heard, after separation, divorce. It's often exacerbated. Denial of fundamental rights, of women's and children's human rights, in the name of a misleading restorative interpretation of severe consequences of male violence against women and children, is also a sort of trend which is really coming in. As we've heard, mediation is also here under this hidden proposals of finding an agreement. WAVE is concerned about these tendencies, this gender neutralization of the problem and the responses to it. It's not easy, of course, at the EU level to legislate. It would be much easier for us also at the national level, where we can hold various actors directly accountable. We are aware that many of the issues that we're mentioning here are unlikely to find a literal and binding interpretation in a directive. But whatever can create, we really want to contribute to create a right cultural context, competence and awareness of this background and of this context, so that whatever is stated is going to be really effective and implementable. So I wish to give a very helpful thank to you as politician, to everyone who is working and making an effort against violence against women, all members of WAVE, the women specialists and activists, and every single woman will be very grateful to you for every step and initiative that can really bring a safe change, not only in her life, but in all society. Thank you very much. Thank you for
Pirrone.
Mrs. Pirrone, thank you very much for your focused contribution and for your statements about the gaps of the directive. Our objective is indeed to improve it with all the necessary amendments in order to have an effective protection for women and children, protect them from violence. Thank you so much. I'd also like to thank all the colleagues who are present here today, Mr. Georgoulis, Mr. Kokkalis, Mr. Arnavanitis, and also Mr. Papadimoulis. Thank you for being present here today. At this point, I would like to invite the President of the European Women's Lobby, WL, Mrs. Reka Safrani, to analyze the gaps in the proposal for a directive on child safety, gaps that I believe do not comply with the standards of the Istanbul Convention and on custody and visitation rights, particularly Article 31. She will also analyze the bad practices of forced visits in cases of domestic violence in the member states and the fatal consequences they have on female victims and their children. The European Women's Lobby is the largest umbrella organization of women's associations in the European Union, representing a total of more than 2,000 organizations and working to promote women's rights and equality between women and men. Mrs. Safrani, you have the floor.
Thank you very much for the invitation and for the work and the commitment that you, Ms. Kountoura, are doing to highlight the issue of custody and children's rights. And I am honored to be able to present our observations and our recommendations to you. And I think this is a great opportunity to make a clear statement on the need to strengthen the safety of women and children as victims of domestic violence together. The EWL, and thank you for introducing us, has an observatory on violence against women, and it is an outstanding and unique structure in Europe, we think, counting more than 25 years of experience. The observatory brings together a dynamic group of women who have extensive experience both from the field and they are also professionals, frontline NGO activists and so on, coming from different countries, acting as a watchdog of policy development and also alerting to the rise of burning issues in Europe. They are highly involved in developing proposals to improve the European Commission proposal for a directive on combating violence against women and domestic violence, a directive that comes after many years of advocacy from different women's organizations across Europe. The EWL warmly welcomes the draft resolution also by the two co-rapporteurs from LIBE and from FEMM committees, so Ms. Frances Fitzgerald and Evelyn Inchier. And we think they have made an outstanding effort to enhance the proposal and ensure that key forms of sexual exploitation that are not in the original text are also included in the proposal and adequately addressed, as for example sexual exploitation for the prostitution of others and for forced sterilization. They have also made an effort to reinforce the proposal in order to give better response to the specific needs of women and as victims of domestic violence. However, the current proposal needs to be enhanced, we think, when it comes to custody and visitation rights and the safety of children and victims of intimate partner violence. As we have heard already, Article 31 of the Istanbul Convention clearly mandates states to ensure the incidents of violence that should be taken into account in the determination of custody and visitation rights, and that the exercise of any visitation or custody rights should not jeopardize the rights and safety of the victim and her children. The right of every child to maintain contact with both parents should be restricted if necessary in the best interests of the child, and we are quite clear about that. However, the proposal for a directive at the moment does only request member states to establish places where offenders can have a safe contact with children, as in Article 24. This is highly problematic in our view, as it cannot be considered on its own the only solution to the problem of children's safety. As a standalone article, it reads as if member states were expected to make the effort to ensure the rights of access to the abuser, despite safety concerns. For the EWL, it's clear that where there is a reasonable doubt concerning the safety of the child, from both a physical and emotional perspective, visiting rights and custody rights should be suspended as a general rule. It is not safe for a child to meet an abuser, no matter if this abuser is his or her parent or not. Let's remember that there are cases of children who were fatally killed during so-called supervised meetings. The current proposal for a directive therefore misses the opportunity to promote a common approach at EU level that ensures that criminal proceedings are not dealt with completely separately from custody proceedings, and that risk factors are taken seriously into account on individual basis. In 2021, the EWL Observatory experts collected examples of gaps and widespread bad practices across the EU, neglecting the obligations in Article 31 of the Convention when it comes to the safety of victims and children. There are far too many examples of countries that have introduced or attempted to introduce mandatory shared custody, specific criminal offences on obstructing visitation, which often apply to mothers, or mandatory mediation for parents, as we have heard before. None of them considering the history of domestic violence. They have also established forced visitation against the wishes of the child. They have also established use of non-valid parental alienation syndrome, as we have heard, to deny or undermine the violence and to instead shift the focus on the woman and blame her for turning the child against the abuser. They have also introduced cases of murderers getting custody rights over the orphan child and even pension rights. And worse, that there are far too many examples of fatal cases of femicide and infanticide all over the EU that are alerting us to the urgent need to act in this field. The current text proposed by the directive acknowledges that, and I quote the text of the proposal for a directive, "It is necessary to lay down a comprehensive set of rules which addresses the persisting problem of violence against women and domestic violence in a targeted manner and caters to the specific needs of victims of such violence." Women's organizations now count on the European Parliament to ensure that the recommendations, its resolution adopted on the 6th of October in 2021, are taken on board of the directive, so that it is acknowledged that intimate partner violence is clearly incompatible with the best interest of the child and with shared custody, and that forced custody and forced visitation are forms of institutional violence that put women and their children in high risk of re-victimization. So therefore, we would like to ask you to please represent these gaps in the directive as well as our specific recommendations. And thank you very much again for this opportunity.
Ευχαριστώ πολύ την Πρόεδρο του Ευρωπαϊκού Λόμπι για τις...
Thank you very much, the President of European Women's Lobby, for her key points. Unfortunately, we've realized that women victims of violence face many challenges because of the obstacles and the difficulties to make justice. Women are exposed to the risk of secondary victimization in criminal proceedings and when seeking compensation as well. And very often we see that perpetrators go on violating women's rights and they have full access to their victims. And they continue abusing their victims. That's why we need to create institutions of specialized courts with specialized judges where with the support of specialist psychologists, child psychologists will undertake to hear family law cases. And then we need to provide for mandatory training of the judicial police and forensic staff on all forms of violence and its mechanisms. At this point, I would like to welcome my friend and President of the Board of the European Network Against Violence, Mrs. Petrolakis, Kiki Petrolaki. Mrs. Petrolaki will talk to us about the vicious circle of secondary and repeated victimization of mothers and children who suffer domestic violence and the role of patriarchy in maintaining and strengthening it. Mrs. Petrolaki is with us online. Good evening. We can hear you. Thank you very much for the invitation. On behalf of the European Network Against Violence, I'm really sorry not to be among you today in physical presence. However, I'm very glad to be able to talk to you about such a serious issue. The fact that I'm the last speaker is also easy for me because we've listened already to so many important and interesting things. So I will mostly be focused on the patriarchal societies and how they can influence the situation, the solution of the problems of violence. So in patriarchal structured societies, or one society such as Greece, well, women are found themselves in a very difficult and subordinate position, and same goes for children. This is by default. Among so many other duties that we women are responsible for is also to be able to create a very good relationship between fathers and children. This has been taking place for many years now. We are doing this for the sake of our children in order to keep our families together, and because we were taught like that, and then they all demand they require us to do so, to continue to do so, even after separation or divorce, even if the divorce or the separation took place because of a case of violence. And then if we do not do so, we are responsible and we are not appropriate mothers. These are stereotypes with an horizontal impact in our society, and we're not surprised by the fact that we see these in women judges and police women, and also in social workers and specialists of mental health, because these people are responsible for research and expertise with all the impact that this could have in women and children. We're not surprised when our laws are biased, laws that are supposed to support victims and to reduce discriminations. We're not surprised because we know why this is happening. This does not, of course, mean that we accept it. It means the complete opposite. We do not accept that because we know that it is not just a coincidence. This is done on purpose. And in such patriarchal structured societies, we need more international conventions, directives, and even a regulation in the future. Why not? We need them to be implemented and not just to be transposed in paper. Because in such societies, such as the Greek society, patriarchal societies, several things are happening. For instance, a very common form of family violence is, for instance, coercing control, which is a very frequent form of mental violence. Or sometimes these are criminals but are not prosecuted. Or there are cases not that they are not considered to be domestic violence, and they are not included in the special law of our country as a form of violence, where when they are denounced, I mean, they are not connected to the domestic violence law. In societies such as ours, in 2021, we are creating laws that are trying to take care of the patriarchal authority. So they offer by default joint custody to all parents for at least 1/3 of the time of the child, unless the parent does not want so. And we're indifferent of the interest of the child, because in our societies we think that children are just our property. Only after femicides we consider domestic violence as a crime. And there has never been a prosecution to a perpetrator for the violation of the child, which is considered to be domestic violence. Not even in the case of Caroline. We didn't have a violation case against the baby that was put on the dead mother. So you see that in our society in 2023 we do believe that a man violating his wife can at the same time be a good father. That's why we have decisions such as the ones mentioned by Mrs. Agathopoulou. Children are given to perpetrators who are condemned. In patriarchal societies, we don't have a clear system of protection of children, and very often we do not even realize what this is all about. Child protection services in other countries is completely different in Greece. It doesn't have to do with the general population of children. So it's just one prosecutor who will deal with the case of a child, an isolated case, if and when he or she is informed. Also, the visit rights is also something that is strictly linked to mothers. We're very suspicious, and we believe that mothers denounce facts, but they're not truthful about this. So we oblige mothers to participate in mediation procedures, and in Greece we have several kinds of mediation cases, because we consider the mother to be co-responsible. We think that domestic violence is just a quarrel between a couple, and we need to make mother co-responsible for that. This is not, of course, we're not very suspicious towards perpetrators, because they use the system against the survivors and against their children. They use penal law. When the mother denounces, well, the perpetrators do other cases, and it has started to become an Islamic state, and we need to do something in order to face this problem. So our proposal is to punish false complaints. In family law, recently, we've listened actually, we have the parental alienation and false allegations. Well, this is something that has started to appear more and more, and parental custody is taken off by non-violent mothers and offered to perpetrator fathers. This is a very important thing. And the thing is that we create this way a cyclical argument. It's a false situation that cannot be denounced. If I ask to limit contact with the father, they will consider me to be an alienator parent, and they won't believe me. If I keep giving my child to the father, well, this means that there is no domestic violence, because otherwise I wouldn't allow my violent husband to see the child. So we need to do things in tribunals, and also to change the legislation as regards all the terms that have to do with parental alienation. So we're talking about parents and their families, and of course, we suggest to stop joint custody cases, even when there is a suspicion of domestic violence. In patriarchal societies, in order to have access to the support, the victims have to fulfill several conditions, very difficult, and they have to pay a lot. We are not taking into account the safety of the children or the victims. We do not take into account the dangers. We do not cover for urgent needs, financial needs, and we do not take care of long-term needs. These things should be working immediately, otherwise we're talking about continuous victimization. No woman will denounce if there is no support for practical issues, housing, surviving, because the way it is now, the perpetrator is facilitated to go on with what he's been doing, because actually his threats are become a fact, and the vicious circle will go on and on, because tools used by perpetrators in order to preserve control upon their victims are very, very specific. We're talking about their children, I mean their parenthood, the lack of balance because they have a better social status, and of course justice. If we rip them off of these privileges, no woman, no child will be obliged to go on living in a violent environment just because they don't have money to survive, to hire a lawyer, and because they are afraid, and they are right to be afraid. If they dare leave the house, the situation will become worse. They won't have any protection, and the perpetrator will, of course, implement all his threats to take their lives, to take the children of the mother. So that's why we're talking about continuous victimization, secondary victimization. Or maybe they can say, talk, do not be afraid. So you are responsible for the domestic violence just because we do not denounce the situation. And when you are convinced to speak, then there is nothing to support you, nothing systematic to take you step by step and to lead you out of this situation. Perpetrators know about this, they use this, and our job is to prevent them from doing that. The only way to start reducing secondary victimization is to start building cooperation between all the interested parties. That means we need to have to activate police, social workers, everybody to work together, and their objective should be to react immediately in order to protect victims, and this of course includes the covering of the needs of the victims. This is foreseen by Article 7 of the Istanbul Convention, and also Articles 40, 41, and the whole of the Chapter 6 of the Directive. We also need a professional. We need to have a point of reference of the survivor, a coordinator who will communicate with the victims. In Article 55.2 of the Istanbul Convention, there are some references made, but it has to do so far with some equality bodies and government bodies. We're trying to do so in Greece, but in reality, our cooperation is very difficult, and we are not sure we will achieve something in the end. We cooperate closely with the Chief of Police of Iceland, who is the country #1 in gender equality, and we're trying to imitate their good examples. So these are things we need to be included in the directive. Domestic violence has to be persecuted immediately. Even if there is no complaint, justice should undertake its role immediately. Yes, sometimes victims do not want to the prosecution of their violators because they are afraid. Children should always be visible. We need to take care of the child that is exposed in gender-based violence and in domestic violence. Urgent protection measures foreseen by Article 52 of the Istanbul Convention and Article 21 of the Directive should immediately be imposed in order to alienate the perpetrators so that the kids won't change all their habits. Approach should be forbidden, and this is something that should be actually asked by everybody, other members of family, not just the victims of domestic violence. Specialized support services, social services, police, prosecution. Even if the victim is not consenting, they should be able to denounce these situations. But it's not just enough to take these protection measures. We need to supervise them, and we need to register all the violations by the person of reference. The police could help. They could, for instance, identify the place of the perpetrator by using their phones. We need to use the support services. The person of reference should inform the professionals of Article 34, supervising communication, the professionals of Article 38 of the Directive. All these people could supervise safety and security and inform immediately the court so that sanctions will be imposed, because when perpetrators are not punished, they do not get the message that they need to stop. All these things, along with Article 33 and 34 of the Directive, should have some deadlines and should be implemented always and everywhere in all domestic violence cases when there are children implicated, and in countries that do not have a clear protection system of children. Furthermore, we would like to add the provisions of Article 31 of the Convention of Istanbul, so mandatory registration of violence cases, safeguards safety of children, and last but not least, if we want to eliminate the tools of perpetrators, we propose to have a lawyer whose actually fees will be taken care by the state. The legal aid is not enough. This will also give a kind of breath to Greek tribunals and courts because there are huge delays, and this is of course very positive for perpetrators. We should forbid mediation when there is domestic violence, and in cases of domestic or family violence, no mediation should take place. And in family law, when there is domestic violence, there should be no mediation whatsoever. So, forensic examination should be linked to each case, and we need to compare all legal and legal cases independently of whether victims are the same or different ones, because sexual violence and domestic violence are always repeated. It's not something that we should realize after the assassination of a child or after a femicide. So we need to be able to compare all cases, and then we need to implement all these that is foreseen by the Article 46 of the Directive, of the Convention, excuse me. So, last but not least, with the conventions and the directive, what is good is the fact that when there is no political will in a country, we have these safeguards. For instance, Directive 29, it has several points that are included in the present ones. We've transposed that in 2017 in Greece with a huge delay, and 6 years later, no progress has been made. Same goes for the Istanbul Convention. It was ratified 4.5 years ago. Nothing is implemented, and GREVIO, actually we're waiting for GREVIO to come and control us, because apart from the non-implementation, there is a big dilemma of how to inform population about these provisions. I mean, why inform these people about their rights when they cannot get these rights in their everyday life? Thank you very much for your attention.
Να ευχαριστήσω θερμά την κυρία Πετρουλάκη για την αναλυτική και...
I would like to thank warmly Mr. Petroulaki for a detailed and thorough presentation. And definitely I would like to point on what you said, the political political willingness not only to pass the laws but to implement in reality legislation and laws. So I would like to congratulate all the speakers for the key contributions, which I will personally take into account when preparing my position in the amendment procedure for the community for the EU directive. You know, it's a huge responsibility to establish because an institutional framework that for the first time will be able to create, it is in a comprehensive and effective way, the necessary protection net for victims of gender-based violence in all its dimension, because no country, no society can take substantial step towards progress and prosperity when inequalities prevail, when gender stereotypes and patriarchal attitudes persist, and when violence is perpetuated, traumatizing the body and the soul of women and children who are the future. The cultivation of a culture of zero tolerance toward gender violence in all its forms must be reflected in institutional decision. Let us not forget that we are all different but equal, and only with absolute respect for fundamental human rights can we make leaps forwards as a society, requesting, looking for, something which is fundamental, a life without violence. Thank you very much.